Judgment in the matter of Smith and another against the Royal Bank of Scotland.
Lord Legate will hand down this judgment.
The Court is giving judgment in two appeals which raise a question about the time limit for bringing a claim under the Consumer Credit Act, seeking a remedy for an unfair credit relationship. The two claimants, Miss Karen Smith and Mr. Derek Burrell, each had a credit card issued by the Royal Bank of Scotland. The bank also sold them Payment Protection Insurance, PPI for short. This insurance protected their credit card repayments in the event of death, accident, sickness, or involuntary unemployment. In selling them PPI, the bank did not tell the claimants that most of the money which they paid for PPI did not go to the insurer, but was kept by the bank as commission. Even to this day, the bank has not disclosed the exact size of its commission, although it is now known that it was well over 50% of the payments made for PPI. Although the details of the two cases are different, the issue in each case is the same, so I need only mention the key facts of one case. Karen Smith made her last payment to the bank for PPI in April 2006. Her credit agreement with the bank continued for another 9 years, until 2015. In 2018, she learnt for the first time that most of the money she'd paid for PPI had been kept by the bank as commission. Just over a year later, in August 2019, Miss Smith brought a claim in the County Court, seeking an order under the Consumer Credit Act for repayment of the money she'd paid for PPI. Her claim succeeded before the district judge and on an appeal to the County Court judge. But on a second appeal, the Court of Appeal ruled in favour of the bank, concluding that Miss Smith had brought her claim too late, after the time limit for bringing it had expired. The Court of Appeal reached the same decision in Mr. Burrell's case. Ms. Smith and Mr. Burrell have both appealed to the Supreme Court. This court unanimously allows their appeals and decides that their claims were brought in time. The main judgment is given by myself, Lord Legate, and Lord Hodge gives a short concurring judgment. The claims are based on sections 140A to C of the Consumer Credit Act 1974, which were added to the Act in 2006. Those sections introduced a new regime intended to be less technical and to provide consumers with more protection than the one that it replaced. Under this regime, the court must first decide whether the relationship between the creditor and the debtor arising out of the credit agreement between them is unfair to the debtor because of one or more specified matters. The specified matters are extremely broad and include not only any of the terms of the credit agreement, but also anything done or not done by or on behalf of the creditor, either before or after the making of the agreement. In judging whether the relationship is unfair, the court must consider the whole history of the relationship. But if the relationship is still continuing, the question for the court is not whether the credit relationship was unfair to the claimant when the credit agreement was made or at any other time in the past. It is whether the relationship is unfair to the claimant, i.e., at the time when the claim is decided by the court. If the credit relationship has ended, the wording of the statute makes it clear that the date at which the fairness of the relationship must be assessed is the date when the relationship ended. If the court finds that the relationship is, or was when it ended, unfair to the claimant, then the court has a broad discretion to decide what, if any, remedy to grant. The purpose of any such remedy is to remove the causes of the unfairness, if they're still continuing, and to reverse any damaging financial consequences of that unfairness, so that the relationship as a whole can no longer be regarded as unfair. On these appeals, the bank does not dispute that in each of these two cases, its failure to disclose the commission that it received for selling PPI made the credit relationship unfair to the claimant. Its main argument is that the claims were brought too late. The bank contends that the claims are barred by Section 9 of the Limitation Act 1980 because their claims to recover money brought after the expiration of 6 years from the date on which the cause of action accrued. The bank's case is that the cause of action, that is the right to claim a remedy, accrued when the payments for PPI were made. As the last such payment by Ms. Smith was made in April 2006, on this basis, the 6-year time limit for bringing a claim to recover the money expired in 2012, long before her claim was brought in 2019. The Court of Appeal did not accept that argument, and nor does the Supreme Court. As I've explained, under the Act, when the credit relationship has ended, the right to claim a remedy depends on whether the relationship was unfair to the claimant at the time when it ended. Ms. Smith's credit relationship with the bank ended in 2015. Therefore, that was when her right to claim a remedy for unfairness existing when the relationship ended arose, and when the 6-year period for bringing a claim began. When she brought her claim in 2019, that was within the 6-year period, and her claim was therefore brought in time. The bank made a second argument, which found favour with the Court of Appeal. This argument is that although the credit relationship between the bank and Ms. Smith continued after she made her last PPI payment in April 2006, after she stopped paying for PPI, the relationship was no longer unfair to her. The Court of Appeal said that there was no financial effect or consequence of the PPI agreement for Ms. Smith, which persisted after she made her last PPI payment in 2006. So the relationship was not unfair to her at the time when it ended in 2015. Therefore, on its merits, her claim that the relationship was unfair to her at that time must fail. The Supreme Court also rejects this argument. We think it clear that the credit relationship remained unfair to Ms. Smith after April 2006 because the bank still retained and did not repay any of the sums which she had paid for PPI cover. That was a financial effect of the PPI agreement which persisted. The relationship also remained unfair to Ms. Smith because the bank did not disclose to her the fact that it had received commission out of her payments, let alone the amount of the commission, which the bank still not disclosed. This was still the position when Ms. Smith's relationship with the bank ended in 2015. So the relationship was still unfair to Ms. Smith at the time when it ended. The Supreme Court also confirms that the Court of Appeal was right to reject another separate argument made by the bank that the claims were excluded by transitional provisions which applied when sections 140A to C of the Consumer Credit Act were brought into effect in 2007. In the result, the claimant's appeals are allowed, and the orders made in the county court in each case are therefore restored.
The court will now adjourn.